So you and your spouse have minor kids, and in case both of you were to die, you've named guardians in your will to raise the kids, but you did not create a trust to protect the assets your kids would inherit. That's another mistake. Let's talk about why. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. Okay, let's talk about why it's a mistake for parents to leave assets to their minor children in a will instead of a trust. Now, by not having your assets held in a trust when you and your spouse die, your assets will need to go through the long, expensive probate court process. Now, you may have heard some attorneys say that Ohio is a probate-friendly state, which there are so many reasons why that's completely false, but for now, know this. There is nothing friendly about probate when minor children are involved. Why? Because the court needs to be involved, and that's going to take time. Someone is going to need to be named executor and get approved to get access to the accounts. All the while, someone is going to need to be paying for things for your kids. And even if the court gives you special access to the accounts, it's still going to take weeks before the person you named to be guardian of your kids gets access to your funds to take care of them. And that's not fair to the guardian, and that's definitely not fair to your kids. Also, if you and your spouse died and left all your assets to your kids in a will, then all of those assets would need to be immediately given to your kids as soon as they turn 18. Now, I don't know about your kids, but most parents have told me that they would be really uncomfortable with the thought of their children getting so much money and assets at such a young age. Also, since all your assets would be distributed to your kids when they turn 18, that means the inherited assets would be owned by the kids in their personal name. And that means your kids' inheritance would not be protected from seizure in the future if, say, your kids got divorced, went bankrupt, or had a lawsuit judgment held against them due to a major accident. Now, on the flip side, if you made sure your kids inherit your assets in a trust, then you could set it up where your kids would only get access to certain amounts of their inheritance as they get older. And if you create a special kind of trust, which our firm calls a lifetime asset protection trust, you can also make sure your kids' inheritance will be protected from any future divorce, lawsuit, or bankruptcy. We can even show you how to set up your lifetime asset protection trust so that it can be used as a vehicle for your children's financial education and personal growth to become an even more well-rounded adult that builds on your family prosperity and legacy. Hey, thanks so much for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can set up a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.